You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diament, founder of Diament Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, episode 132. What's better, trade dress protection or design patent protection? My name is Adam Diament, a registered patent attorney and founder and owner of Diament Patent Law in Los Angeles. Let's dive into the subject. Let's first start with a couple definitions. Trade dress falls under the same laws as trademarks and is to protect the characteristics of visual appearance of a product or its packaging that signify the source of the product to consumers. So it's about design and shape. But isn't that what design patents are all about, protecting design and shape? It is, which is why it can get tricky on which is best or even which one is right for you. In a design patent, you're protecting the appearance and not its structure or functionality. It has to be ornamental, not functional. A court is going to look to see if your design is essential to how it works. For example, if you have a new coffee cup handle, the handle is functional, but maybe you have a new interesting look of your handle, so you can get protection on that interesting look. A court is going to see if there are alternative ways to make the product. If no, you're not likely to get protection for that, or it would be very limited. To get design protection, the design must be an article of manufacture, ornamental, new, and not obvious over existing prior designs. For trade dress, it has to be a source identifier, be distinctive in the marketplace, be used in commerce, and it must also primarily be non-functional. For the non-functional part, it's going to be applied more strictly in trade dress. To get protection for trade dress, the trade dress must be inherently distinctive unless it has acquired a secondary meaning. What inherently distinctive means is that it must be unusual and memorable and conceptually separate from the product. And it's likely to serve primarily as a designator of the origin of the product. Secondary meaning is that maybe it's not that distinctive, but over time people have begun to associate that particular look with your brand. Some easy categories that are clearly better for trade dress are the look of a store or most packaging. Apple has a trade dress on its Apple stores. It doesn't really matter if you're placing a chair in a different location or you have one extra table. You know the Apple store look when you see it. It's distinctive and they have a trade dress for that. There's a famous case from 1992 called 2 Pesos Inc. versus Taco Cabana Inc., where two Mexican restaurants had very similar decor, which had particular colored stripes, distinctive outdoor umbrellas, a certain kind of buffet style. And these kinds of things, such as restaurants, really only fall under trade dress and not design patents. In a design patent, you're comparing the drawings in your patent application to what someone else is doing. And a person must think that these drawings or the product or the store is substantially the same as what's in your design patent. If the store has tried to do a design patent, they would have to submit drawings of a particular layout. And if someone just did something similar, but maybe changed the shape of the tables to circular tables compared to rectangular tables in the drawings, they might be able to get around design patent infringement because what was done in real life doesn't look the same as the drawings. Trade dress is often a little bit more holistic because it's based on consumer confusion. In the above example, if someone placed rectangular tables with, let's say, oval tables, there's a good chance that when people walked in, if it was the Apple store, they would say, like, oh, I thought this was an actual real Apple store. For trade dress, there has to be consumer confusion, and that the average consumer will likely be confused as to the product origin if another product was allowed to appear in similar dress. Another type of good that often falls into trade dress is a particular packaging look with a color scheme, like a Tiffany's jewelry box. It might be a regular box, but it has that Tiffany blue color. That's good for trade dress because in a design patent, you aren't protecting color, but ornamental features. If color schemes are important, like Christian Louboutin shoes with the red sole, that's trade dress. Why? Because if consumers see a red-soled shoe where the rest of the shoe isn't red, the consumer is going to think it's a Louboutin shoe. If they try to get a design patent on it, and I've never seen a design patent that has color, I'm not even sure if it's allowed, but if it was a design patent, someone would have to copy the entire shoe shape and features, not just a sole coloration. Now, there are some shoes that are so iconic in their three-dimensional shape that they could be design patents, but it wouldn't be good for someone trying to protect for a color on the bottom of a shoe when the shape of the shoe could be any shape. For infringement, the tests are going to be different. If we're talking about trade dress, are the consumers likely to be confused as to the source of the goods, who's making it? The court's going to look at the similarity of the designs, the sophistication of the consumer, similarity of the goods, market impact. In trade dress, it's easier to argue that there's no confusion when looking at the product design as a whole, because it's all about whether the consumer is going to be confused as to the source of the goods. For a design patent, we're looking at the similarity of the goods by themselves and determine if the defendant's design is substantially similar to the patented design from an ordinary observer standpoint. We don't look at market impact and other factors. If it's just a design patent, we're looking at the potentially infringing product side-by-side comparison. Technically, it's not a consumer confusion in the marketplace standard. It's more like if you held up the drawings in the design patent and then looked at this other product, would an ordinary observer think that they're the same? Now, oftentimes you might come to the same conclusion, but there are differences in that standard. Another big difference is whether you are making the goods or not. Since trade dress is all about identifying sources of goods, if you want trade dress protection, you have to actually be making your product and have it publicly sold, because if you're not making it, then there's no consumer confusion as to the source of the goods. In a design patent, you can get protection even if you never make your product. What you get for protection for can just be on paper. You have drawings in a design patent, and that's what you get protection for. Let's say you thought of a cool looking new vase, and you never made this vase, but you filed a patent application, you got a design patent for it. Someone saw your design patent, copied your drawings, and made it into a physical vase. If you're the design patent holder, you can still sue for design patent infringement, but you couldn't sue for trade dress infringement because you never put this product into the market. Let's take the vase example. Let's say there are lots of parts of the vase, and most of it's just normal run-of-the-mill vase shape. But you have one tiny little section where you made a special curly segment. And basically, you're just getting patent protection for that special curly segment. If someone else makes a vase that has that curly segment, you might be able to sue for design patent infringement easier compared to trade dress infringement. And that's because people might not even be noticing that interesting curly section, and plays no role in where consumers think who made that vase, even if someone copied that exact part. But if you do a side-by-side comparison of just that little curly section, the part that you got a patent for, it might be so similar that people would think those curly sections are the same ones shown in the design patent if you're holding up the patent drawings compared to the product right next to each other. Another difference in infringement is that trade dress can theoretically last forever as long as you continue to use the design and it continues to act as an identifying source of the goods. But for a design patent, it lasts only 15 years. Another difference in trade dress and design patent is that since a design patent has to be new, useful, and non-obvious, if you've been selling your product for a while, usually a year or more, you cannot get a design patent on anymore because your product isn't considered new. But that's not the case for trade dress. You can be selling your product for a long time, having that interesting design, and then file for trade dress protection. And actually, you can get some trade dress rights even if you don't register it. And in fact, the longer that you're using your product in public, the easier it is to get protection, because the longer you've been selling your product, the more likely you can make the argument that consumers identify the look of your product with your brand. It might be easier to get higher damages awarded in design patent compared to trade dress because how the laws are written and interpreted, but I'm not going to go into those details. Sometimes it's a simple answer on which is best for you to get. If you're trying to protect the overall look or concept, like the theme of a store or a particular color scheme or the appearance of packaging that could be different based on what's inside the package, but there's a general package theme, then trade dress is probably for you because knockoffs may not look exactly the same, but would still confuse consumers. If you have a very particular exact shape of something, like a particular kind of cell phone shape, or a new vase, or a new mug, then that's something that's probably more well-suited for a design patent. But there are situations that might be in a gray zone, and you can file for both trade dress protection and design patent protection. Consider trade dress, especially if you've been in the marketplace for a while and you can show that people associate a certain look with your brand. And depending on if you've been selling your product for more than a year, it may actually be too late to get a design patent. So that's the ins and outs of trade dress and design patents. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamentpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamentpatentlaw.com or call me at 424-281-0162. I'm Adam Diament, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. For more information and help with your own intellectual property needs, contact Adam Diament directly by going to diamentpatentlaw.com. That's DIAMENT patentlaw.com. Or click the show links to connect by phone, text, or social media. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.